Hello, Anna. Anna, can you hear me?
Hi, David.
Hi, Anna. How are you?
Good. I cannot hear you.
You can't hear me?
Cannot hear you. Let's see.
David, this is Brian Haverly, I can hear you, and I can hear Anna. Ms. Kimberrock, can you hear me?
I can hear you, Mr. Haberly.
Excellent.
What's going on here? Is your microphone working, David?
They can, other people can
I
hear
cannot
me.
hear you.
Other people can hear me and I can hear you.
Mm.
Can you hear me?
Mm.
Mr. Albright, can you hear me?
I sure can. Yep, just checking in as well. Thanks.
You bet.
Didn't know that you'd gotten the case there, David.
Yes, I did.
Morning, Jeff.
Good morning.
Good morning, everyone.
Morning, Mr. Hearing Examiner.
I assume then you can all hear me.
Yes, sir.
Yes.
Yes,
Good. Before we start, I indicated in my order scheduling this status conference that only attorneys would be allowed to participate, and that all others could view the proceeding via our YouTube link on the Commission's website. And I see 4 names in the waiting room for this Zoom conference that I don't recognize as attorneys who have entered appearances in this case. Let me ask the parties if they're familiar with these names. J. Alvin Leaphart.
yes. This is Richard Virtue. He's the Los Alamos County Attorney.
Has he entered an appearance in the case?
No, he hasn't.
Okay. Well, he will not participate then. There's another one, Philo.
Yeah, Philo Shelton is the Los Alamos County Utilities Director.
Okay. Kevin Powers.
He's the Assistant Los Alamos County Attorney.
And I take it has he entered an appearance in the case?
No, he has not, Mr. Hearing Examiner.
Okay. And then I also see Thomas Singer, and I recognize him. He's not an attorney, is he?
No, Mr. Hearing Examiner. He's staff with Western Environmental Law Center, but he's not an attorney and has not issued an appearance in the case.
Okay.
I can let him know about the YouTube link.
Okay. And now I see a phone number showing up, 505-662-8333. Does anyone recognize that?
Do not.
Okay.
This is Richard Virtue, Mr. Hearing Examiner. That appears to be the main number for the Los Alamos County Utilities Department. So I would expect that another staff member from Los Alamos County Utilities Department is on the line.
Okay. Well, none of those people will be allowed to participate. As you can see, there are many people, many faces on these screens, and it's actually impossible to manage if we're going to have that many people beyond the attorneys. Just the attorneys, the number of attorneys are going to make this difficult to manage. So that's why we're making available the YouTube feed so that people other than attorneys can participate.
Mr. Hearing Examiner, I do not believe it was their intent or proposal to participate. My understanding is they're on just to monitor the meeting.
Okay, well, they can do that through the YouTube feed. I will not admit them into this Zoom video conference. I'd like to start by getting some introductions here. I've met most of the people on this screen here, but not all. In terms of my introduction, my name's Ashley Scheinauer. I'm the hearing examiner who's been assigned to this case. And I've also asked a court reporter to be present today, David Lee. You'll see him up in, well, at least in my top corner of my Zoom screen. It's not the usual practice to have our status conferences transcribed, but today we're going to be discussing some important issues, and more than the usual important issues that we discuss in a scheduling conference. And I thought it would be well to have him be present. So that's Mr. Lee up there in the corner. Next, I'd like to find out who the attorneys are and who you all are representing. I'll start with Avangrid.
Mr. Hearing Examiner, Brian Haverly and Kurt Weil on behalf of Avangrid, Avangrid Networks, and NM Green Holdings.
Okay. Kurt Weil must be on my second screen. I don't see him immediately.
Do you want to unmute and say something, please?
Yeah, that might help. Oh, there he is. Okay, I see him. Okay, good morning, Mr. Weil. Okay, PNM.
Yes, good morning, Mr. Hearing Examiner. This is Rick Alvidrez, and with me today is Stacy Goodwin, Associate General Counsel, appearing for PNM Resources and PNM.
Okay. CCAE.
Stephanie Zur on behalf of Coalition for Clean Affordable Energy.
Morning.
Good morning.
WRA. Ms. Beatles, you're muted.
There. Sydney Beatles for Western Resource Advocates. Thank you and good morning.
Good morning. No Steve Michael today?
No, he's out of town.
Okay. The Attorney General.
Good morning, Mr. Hearing Examiner. Choya Corey and Gideon Elliott on behalf of the Attorney General's Office.
Good morning. Interwest Energy Alliance.
Good morning. This is Joan Drake, and with me this morning is Haley Adams on behalf of Interwest Energy Alliance.
Okay, good morning. New Energy Economy.
Good morning, everyone. Good morning, Mr. Schnauer. Marielle Nanasi on behalf of New Energy Economy.
NM Area.
Mr. Hearing Examiner, Peter Gould and Kelly Gould.
Good morning.
Good morning.
Sierra Club.
Good morning, Jason Marks for Sierra Club.
Good morning. The Albuquerque Bernalillo County Water Utility Authority.
Good morning, Mr. Examiner. Keith Herman with Stelzer Winter Law on behalf of the Albuquerque Bernalillo County Water Utility Authority. Also present is my co-counsel, Dal Harris.
Okay, morning. City of Albuquerque.
Good morning, Mr. Schnauer. Jane Yee on behalf of the City of Albuquerque. Good morning, parties.
Good morning. Bernalillo County.
Good morning, Mr. Hearing Examiner. Jeff Albright on behalf of Bernalillo County.
Westmoreland Mining. Don't see Catherine Coleman here. Okay. County of Los Alamos and MSR Public Power Agency.
Mr. Hearing Examiner Richard Virtue on behalf of Los Alamos County and MSR.
Good morning.
Morning.
Danae Care, San Juan Citizens Alliance, Nava Education Project, and I'll mispronounce this, Nizoni Ani.
Yes, good morning, Mr. Hearing Examiner. Kyle Tisdale. I'm joined by my co-counsel, Allie Beasley, on the call today as well. And we represent the coalition of community groups, San Juan Citizens Alliance, Danae Citizens Against Ruining Our Environment, Haudenosaunee, and Nava Education Project. Thank you.
Good morning. City of Farmington.
Good morning. This is Randy Bartel on behalf of the City of Farmington, also appearing on behalf of Enchant Energy Corporation and Walmart Inc.
Good morning. The IBEW Local 611.
Justin Lesky for IBEW Local 611, sir. Thank you.
Good morning. Onward Energy Holdings.
Good morning, Your Honor. Joseph Yar on behalf of Onward.
I'm sorry that.
Mr. Lee, did you get that?
I did.
Okay. Okay, Kroger.
Good morning, Mr. Hearing Examiner. Kurt Boehm appearing on behalf of the Kroger Company.
Okay, good morning. Berendo Energy.
Good morning, Your Honor. Casey Canelio appearing on behalf of Brendo Energy.
Good morning. And staff.
Good morning, Mr. Hearing Examiner Brad Borman appearing on behalf of Utility Division staff.
Hey, good morning. Did I miss anyone? Okay, I guess the first thing I want to deal with is Brendo Energy. Ms. Canelio, your filings continue to indicate that there's a Pro Hoc Vice pending. Can you explain what that's all about?
Yes, I'd be happy to, Your Honor. So local counsel Carl Kumley, who is with my law firm Dietz and Davis, he has been waiting on his certificate of good standing from California, and has been dealing with an issue with his California CLE certification that we are working through, that we expect a resolution by the end of this week. And we have been in contact with the Pro Hoc Vice department with the New Mexico Bar, and they had advised us to hold off on filing our Pro Hoc motions that we have ready to go to file until Mr. Kumley's California issue was resolved.
What's that California issue?
So he is licensed in California and Colorado, as well as New Mexico. And so he needs to provide a certificate of good standing from California in order for his New Mexico license to be reactivated.
He's currently inactive?
That's correct.
And you expect it to be resolved by the end of this week?
I do, sir. Yes.
And so a motion for Pro Hoc Vice admission will be filed next week?
That is my hope, and I do know that the New Mexico Bar is very expeditious in processing those. So I'd be happy to keep you apprised in terms of when we would be able to submit that with the New Mexico Bar.
Okay, well, I'd like to get that resolved. I mean, you folks have filed your motion to intervene back in early March, and now we're in May. So, get that resolved as soon as you can.
Yes, Your Honor. Thank you.
Okay, then let's move on to scheduling. That's, of course, the original purpose of this status conference. But I'll let you all know I'm having a difficult time with that issue. And I'll tell you why. You're all familiar with the parties' dispute over whether the schedule should address the stipulation or the company's original application. But I learned this weekend from a report in an industry newsletter that Avangrid's electric utility in Connecticut, the United Illuminating Company, was assessed a $2.1 million civil penalty just last Thursday. And the penalty was issued for the inadequacy of the service that it provided following a tropical storm last summer. And that penalty turns out that penalty followed an order that was issued on April 28th for the same reasons, that reduced the company's return on equity and ordered a management audit. And the management audit appears, at least in part, to be directed at the organizational structure involving the utility and various Avangrid affiliates. I then checked Avangrid's recent filings with the U.S. Securities and Exchange Commission to see if there was any further information about the Connecticut problems there. And there was, but I also saw a host of other enforcement actions involving each of Avangrid's 3 other electric utilities. I saw reports about enforcement actions against Central Maine Power Company, New York State Electric and Gas Company, and Rochester Gas and Electric Company. I saw that those companies were assessed penalties and cost disallowances of approximately $23 million in the last 16 months. That amounts to $25 million in penalties and disallowances regarding poor service in just the last 16 months. I also saw that the Maine Public Utilities Commission had ordered a management audit of Central Maine Power Company that appears to be directed at the organizational structure involving the utility and its various Avangrid affiliates, similar to the audit that seems to have been ordered in Connecticut. All of this was news to me. I don't recall seeing anything about these matters in the record in this case. These enforcement actions are clearly relevant to the commission's consideration of the request in this case, in my opinion. I mean, will there be similar problems in New Mexico if the merger is approved? I guess what I'm puzzled, and I'd like the attorneys for Avangrid and PNM to address this. Have I missed something in the record? Is there anything that's been provided about these actions?
Mr. Hearing Examiner, in the record itself.
I'm sorry, if you could state your name.
Oh, sorry, I apologize. Brian Haverly on behalf of Avangrid. Mr. Hearing Examiner, if I could. So I believe that some of the issues in Connecticut were addressed in Bob Kump's rebuttal testimony, Robert Kump's rebuttal testimony. I am not sure about the UI Connecticut issue you just raised or some of the others. There's been discovery that the parties have conducted that we have produced information about various ongoing enforcement actions. But in terms of the record that is before the commission, I think the only thing that is probably in the record is the Connecticut issue.
Well, I read Mr. Kump's testimony this weekend also to check on what he disclosed. And I noticed he had a discussion about a poor customer service satisfaction rating that was received in regard to the Central Maine Power Company. And he discussed what the company has been doing to address that. There was no mention of the enforcement action.
Okay.
All he talked about was the company's response to the poor customer service survey, the JD Power survey.
So, Mr. Hearing Examiner, I have no doubt you're correct. I was just remembering what we had put in this testimony. We are happy to address that in any way you would like us to do so, whether that's briefing, whether that's supplemental testimony, however you would like us to deal with that. We can deal with all of those issues, and we will.
Well, I'm not sure that supplemental testimony is really appropriate at this point. I need to decide whether to address the stipulation or whether to address the original application. And so I'm going to need something more from the company about these issues. And I'm trying to, what I'd like to do today is get the parties' views on what to do about it. Do any of the other parties, I don't know if this is news to the other parties. Do the other parties have any ideas about this? Any thoughts, any suggestions?
Actually, Marielle Nanasi on behalf of New Energy Economy. Some of our discovery has gone to these very issues. The responses have been inadequate. And one of the things I was going to raise with you, Mr. Schnauer, is that, I mean, depending on what's going to happen with the schedule, that the failure to answer questions in discovery, I wanted to ask if they were inadequate, that given the whatever time schedule is before us, that there could be costs assessed if we are successful on a motion to compel. I will just say, without going into the issues, that there have been numerous discovery questions that have just literally gone unanswered. And some of them have to do with these very questions that you are raising right now. Thank you. So I'd like there to be some kind of award of attorney's fees if a motion to compel after a attempt at good faith negotiations is unsuccessful, and you should award that request.
Any other thoughts, comments?
Mr. Hearing Examiner, Rick Alvidris on behalf of PNM and PNM Resources. To address your issue a bit, the topics of customer complaints and other issues with respect to Avangrid's other utilities have been extensively addressed in discovery, and Avangrid has provided quite lengthy explanations. All of these discovery requests, to my recollection, occurred prior to the rebuttal testimony. And so, the parties appeared satisfied with the explanations that Avangrid provided, which of course, they didn't, for the most part, choose to include in their testimony as an issue. With regard to the issue that Ms. Nanasi brought up and the assessment of costs or what have you, I think that's highly inappropriate. There's no motion to compel presently before you. If there was a problem with the discovery responses, it should have been conferred about. I can tell you that the issues that Ms. Nanasi has brought to us with respect to discovery that we have conferred about and have resolved. And so, I don't think it's appropriate to start bringing in sanctions and adequacy of discovery at this juncture. I mean, you've raised a question. You have some questions about service with respect to some Avangrid affiliated companies. Of course, the proposed stipulation in this case has a lot of assurances built in with respect to customer service protections and standards and what have you. This was an important issue for staff and some other parties, and certainly Avangrid and PNM are highly sensitive to that. There are other safeguards in place with regard to how the PNM will be set up as a separately operating company and what have you. But I think the important thing is that you get the clarification or answers that you have to the questions before you. And it seems like perhaps one way of accomplishing that is a bench request if we're not going to be looking at supplemental testimony, but we do have an outstanding bench request already that we're going to be responding to. We propose to move up the response date to the 18th rather than the 24th that addresses this issue. But I think there are certainly mechanisms to get this timely addressed and proceed, hopefully, on the stipulation, which has many, many benefits to New Mexico and to PNM's customers.
Well, am I the only one who's troubled by this? I mean, there's the Avangrid informed the SEC in its reports about these problems. $25 million in penalties and disallowances regarding poor service, and nothing provided to the New Mexico Public Regulation Commission in connection with the proposed merger. Does that concern anyone? Mr. Wright. Yes. Or you're just raising your hand?
No, I was going to ask to make a few comments, Mr. Hearing Examiner.
Please.
Just, some of this just recently came to light. Obviously, the April 28th filing wasn't really, we didn't become aware of that, and the $2.1 million sanction we didn't become aware of until this week. It was, I'm sorry, late last week. I also noticed that there was a bench request that was issued by Commissioner Byrd, I believe it was, requesting data with regard to the complaints and so forth. I believe that's due on May 24th, although I could be wrong on that date as well, which might show some additional insight. I think part of the problem is the fact that there are so many different organizations and affiliates and subsidiaries and so forth, that the structure is extremely complicated and confusing. We look at the Texas filings and we look at these filings here and so forth, and the charts and the matrices of these companies, it's sometimes difficult to unravel exactly what's going on, and we, the county, have a concern about that. That is just not clear, and it's not clear in the record. And we do think that it does raise issues with regard to, this is the first vertically structured, what I would call vertically structured utility that Avangrid is purchasing. The others are redistribute or resell, essentially resell of power that's bought, all those that are in the east. So this is a very different situation, and the first one for Avangrid that I'm aware of, that they have a vertical structure that they're buying. So we have concerns along those lines.
Mr. Examiner, Keith Herman with the Water Authority.
I'm sorry.
Keith Herman with the Water Utility Authority. I would just like to echo that we are also concerned about these penalties as it reflects on the possible performance we would have moving forward. However, due to the scheduling mess we're in right now, I unfortunately can't suggest a good method of dealing with it. Thank you.
Mr. Hearing Examiner Peter Gould for NM area. We are very concerned about that. And as Mr. Albright pointed out, the big issue with UIL just kind of popped up on our radar last week. Without arguing testimony, that is why our focus, as you are aware, in our testimony has been very, very strong local controls on this utility, and very, we think, reasonable request to make sure that if this merger is approved, that quality of service can be protected. But having say that, we didn't address that extensively in our testimony. What we did is we said, here's the structure that the commission should adopt to ensure that going forward, we can prevent these abuses, or at least help to prevent these abuses. But I would, and I don't know if this is the appropriate time to do that, but we have had very much difficulty in this case dealing with this company because they do not seem to understand that they have to play by the rules. We have witnessed, observed extensive participation by a DC attorney on behalf of Avangrid, writing detailed submissions that ended up in this stipulation, conducting settlement negotiations, and there has been no pro hoc vice filed on behalf of Mr. Schwartz. My reading of New Mexico law is his active participation in this case is the practice of law. So either he is violating the statute that prohibits the practice of law without being a member of the bar, or filing a pro hoc vice, or they just don't care. We have brought, well, this is not a new issue. We brought it up in the first party-wide settlement negotiations that you ordered. I have exchanged emails with Mr. Haverly several times on this issue. And in addition, they are not negotiating in good faith, as I would define good faith, because whenever we get to a stopping point where we don't agree with what they have proposed, they go behind our back to our client. They've done it at least twice, and there are probably more instances of it, with attorneys, with representatives of Iberdrola, and with representatives of Avangrid.
Mr. Hearing Examiner, I object to all of this.
Well, wait a second. Let me finish. So, in addition, yesterday.
Hold on. Let me.
So this is a.
I'm not interested really in hearing argument or discussion about that particular issue today.
Okay, then how do we address it, Your Honor?
Well, motions. That's how you address these problems. You file a motion to complain about what you have to complain about, and you ask me to do something about it. I'm not going to be issuing an order or hearing argument on something, on that particular issue without having a motion in front of me. And
Okay, we will
to
file
do
a
it.
motion, but we had thought in terms of enforcing the commission's rules, we are asking you to be proactive. So we'll file the motion, but this is, we think, is squarely within the delegation of authority of the commission to you under Rule 29. I think it's B7 to regulate the course of this case, but we
not
will file the
disagreeing.
appropriate motion. Thank you.
I'm not disagreeing with you about the extent of my authority in the case, but what I am disagreeing with you about is how to have that issue be raised.
Okay. Well,
And
going back to the first issue, we will be raising these performance issues in whatever rebuttal we are allowed, or whatever testimony we're allowed in whatever schedule you provide. And we would appreciate it if this commission had in front of it the same type of detail that other commissions have been provided, as you mentioned, the SEC. We just became aware of the big issue with the Connecticut utility this last week, as Mr. Albright said, but it is very concerning, and it does go directly to the issue of, is this company ready and able to provide the type of service that PNM has provided over the last nearly 100 years, the same quality. I mean, we've all had disagreements with PNM and bumped heads with them, but their reliability has generally been pretty high. Now in their customer service, we've never had the level of fines on any comparable basis to what we're seeing now with these other affiliates. Thank you.
Mr. Hearing Examiner, Brad.
Yes.
Utility Division staff, if I may.
Go ahead.
Thank you. I acknowledge your dilemma on this. We share some of these concerns. I know that we raised some of these service quality and reliability issues in our testimony, not necessarily the issues that you've identified, but we have raised some of these issues. I think our recommendation in going forward might be to issue a bench request to the joint applicants and then allow the other parties to respond to that in order to allow for due process. I think that might be the fairest way to go forward.
Any other thoughts?
Mr. Hearing Examiner Mariel Nanasi, on behalf of New Energy Economy, we have a witness who will be be providing rebuttal testimony about exactly these matters. So that's what we're working on right now. I just want to also state that the largest fine that was ever given out to any company ever by the Maine Public Utility Commission was $10 million against Avangrid.
Mr. Albright?
Yes, Mr. Hearing Examiner, compounding this, if we look at the stipulation, for example, it talks about joint applicants and as applicable, Iberdrola will fulfill all merger commitments. And again, it's just, it's confusing and so forth. In that Iberdrola is not a joint applicant in the proceeding. They were very clear in the initial testimony that they weren't an applicant, and yet there are representations throughout, at least a couple of them, where Iberdrola is involved, but they aren't a signatory and they aren't a party in the proceeding, and they aren't subjecting themselves to the jurisdiction of the Public Regulation Commission. So I think it shows the pattern again of just the confusing issues we have with the organization and with local control and some of the other things that we have brought forward on behalf of the consumers. I think it just is a confusing landscape, and I think that's, I won't say it's by intent, but it's certainly very, very convoluted and causes a lot of issues that just have not been resolved.
Well,
Judge, could you ask the parties to state their name before they speak? I just can't pick them out.
I'm sorry, David. That was Mr. Albright.
Mr. Albright. I got you.
My apologies, David.
No problem at all.
This is Brian Haverly, Mr. Hearing Examiner. I'd like an opportunity to respond to these.
Go ahead, Mr. Haverly.
Mr. Hearing Examiner, nobody has brought a motion to you saying anything about Iberdrola being an applicant. People have complained about it, but there is no motion pending before you. We have made the required representations under the rules on behalf of Iberdrola. But my reading of the rules is that they do not have to be an applicant. They just have to make representations in the Class 2 transactions. Other things about discovery left unanswered, I don't know what that's about. I have responded to every single good faith letter that has been sent to me, and I don't know what those allegations are, but I'm sure we will work through them. We are happy to answer a bench request. We have given people lots of discovery about things that go on with the other utilities that Avangrid owns, and I have nothing to hide about it. We will give you whatever information the commission would like in a bench request. That is a fine thing for us to do. You tell us what you want to know, and we will give you the answers and the information that you would like.
Okay. Well, that's what I'm going to do. I'll be issuing an order later today, that requires information from Avangrid and PNM regarding these issues. And I'll set a deadline for that. And then I will give the other parties an opportunity to respond to that. And I'll set a deadline for that too. And based on that, we'll move forward. Well, I suppose I should schedule another status conference to talk about that. And that's what I'll do. I'll be issuing an order today on those 3 points. Is there anything else we need to talk about this morning before we conclude?
Yes, so Mr. Hearing Examiner Richard Virtue, on behalf of Los Alamos and MSR, just wanted to make the hearing examiner and the parties aware that my clients have reached an agreement with Avangrid and PNM on our issues related to the decommissioning of the San Juan Generating Station. And we are prepared to sign the stipulation conditioned on the Los Alamos County Council approving that. They are scheduled to meet Thursday evening to consider that. And so if they do approve, we will be taking some action to be added to the stipulation as soon thereafter as possible. My understanding of the hearing examiner's order vacating the schedule established May 7th as a deadline for submitting a stipulation. And so I would ask if the hearing officer has any direction in terms of providing an extension on that or following a procedure that would allow us to be added to the stipulation at this point.
I guess the appropriate way to address that is with a motion.
Okay, thank you.
Mr. Hearing Examiner Peter Gould and Ameria, a question about that and then a supplemental question on Rule 20. We would like to see whatever the language is that they've agreed to. I would assume that Mr. Virtue, being a careful attorney, is going to take whatever language the county agrees to, and there would be an application in that motion to add that language to the stipulation. I'm addressing my question to Mr. Virtue, but really my question is to the hearing examiner: what kind of process would that involve? And then I do have a supplemental question on the 5-day deadline under Rule 20 to file objections to the May 7th stipulation that's coming up tomorrow. And given the uncertain nature of the schedule, I wonder if we can waive that until we have more certainty about how that stipulation is going to be handled. Thank you, sir.
Mr. Albright?
Yes, Mr. Hearing Examiner, David, Mr. Albright, on behalf of Bernalillo County. We have the same concern in that seems to be a moving target here with additions that that get added to what should have been a final stipulation as of May 7th. So we haven't seen, as far as I know, we haven't seen the language that's been incorporated on behalf of Mr. Virtue's clients. Don't know if it will substantively alter our position on any of the items that are already in the last stipulation that was filed, which we saw at the time that we saw at the time it got filed or after it got filed. So same question as Mr. Gold had with regard to either additional time for filing objections to the stipulation or some opportunity to take a look at what's been filed. There were various additions to the final stipulation that were added that had not been part of previous testimony or rebuttal testimony or anything in the application as well. So we have some concerns along those lines.
Okay, anyone else on that issue?
Mr. Examiner, Keith Herman with the Water Utility Authority. We support everything that NM area and Bernalillo County have said. Without deciding today whether or not we're hearing the stip as filed, is going to have great impact, not just on this case's schedule, but on the entire commission schedule moving forward. So we would definitely appreciate some clarity on how we're going to proceed in this case. Thank you.
I would appreciate some clarity.
Mr. Hearing Examiner Richard Virtue, along those lines, just for the purposes of clarification, the language that we've agreed to is simply one paragraph that would be added to the stipulation that would address the approach to the decommissioning of the San Juan plant. That's all that has been agreed to, and that's all that would be added. We do think it would be appropriate to allow that language to be added in the interest of efficiency, because it would put my clients on the stipulation and eliminate the need for us to present testimony in the case. So that's what is happening and why we think it's appropriate to go ahead and just allow us to be added to the stipulation.
Okay, well, I'm aware of testimony that's been filed in this case about community group concerns about decommissioning. So I'm sure those community groups will have some interest in what it is that you are agreeing to. I will, in the order I'll be issuing today, I will be suspending the deadline for filing the statements of objections to the stipulation until we get a little bit more clarity on on this whole thing. Anything else we need to discuss? Okay, well, thank you all, and I'll be looking forward to the responses to the order that I issued today.
Thank you, Mr. Hearing Examiner. We will get them to you.
Okay, thank you. And Mr. Lee, thank you for your short participation on short notice.
No problem at all, Judge.
Okay. Okay, so long,
Thank you,
folks.
Mr. Hearing Examiner.
Yep.
Mr. Hearing Examiner, the YouTube disconnection.
Okay. Give me one moment.